Hello, my name is Lindsay Crutcher, and today we'll be discussing the basics of confidentiality, informed consent, and advanced directives. We'll begin with confidentiality, and according to the American Nurses Association, or the ANA, protection of privacy and confidentiality is essential to maintaining a trusting relationship between healthcare providers and patients. It is also essential to professional practice. Confidentiality, as defined by Yoder and Wise, is the patient's right to privacy of health records. Institutions can avoid a breach in confidentiality by allowing access to patient data only on a need-to-know basis. Examples of this would be physicians in nursing and direct care with the patient, techs, therapists, and social workers. Anybody else who would like to receive information on a patient's record needs to have written or verbal consent from the patient. The Federal Health Insurance Portability and Accountability Act of 1996, more commonly known as HIPAA, has expanded patients' rights to confidentiality concerning protection of health information. Exceptions to this would be statutory or legal duty to report. There are some things that must be reported to public health agencies, such as gunshot wounds, abuse, or communicable diseases such as Ebola. Another exception would be the duty to warn. Nurses may have a professional duty to warn an intended victim when a patient makes repeated serious threats towards them. As a nurse, it's important to document all the threats very thoroughly because a case like this may go to court. Here are some best practice tips from Westrick to help nurses better comply with HIPAA. Number 1, use social media with extreme caution and attempt to not inadvertently disclose information of a patient. Number 2, be conscious of all your surroundings when using a computer in the hallway or a computer on wheels. Number 3, use cover sheets on patient care documents and personal notes within the workspace. Number 4, properly dispose of any identifying patient labels, medication packages, or patient care summaries in the appropriate shredder bins within your unit. Number 5, remember that curtains are not walls, and in an area where curtains are your only dividers, be careful when discussing patient information. Number 6, verify callers that are wanting information on patients. Have a safe word or 2 patient identifiers and still minimize the amount of information given because you never know who's on the phone. Familiarize yourself with the company policies and procedures for the use or misuse of confidentiality or patient information. The misuse of patient information can result in consequences. Those consequences could be exposure to a civil suit, a disciplinary action by the Texas Board of Nursing, such as suspension or revocation of your nursing license. You may ultimately lose your job if the company you work for has a no tolerance policy. And last but not least, by violating HIPAA, you could receive fines or possible criminal charges. Now we can move along to the basics of informed consent. Informed consent is the process of receiving permission before conducting a healthcare intervention. A lack of informed consent to a medical procedure entitles the patient to sue for battery. Informed consent is a professional standard of conduct and goes between a patient and a physician. As a nurse, it is important to know that a physician or advanced practice practitioner must be the one to A, describe the procedure in detail, to B, explain risk versus benefits and alternative treatments in lay terms that the patient can understand, and C, to ultimately obtain the consent. The responsibilities of a nurse according to Westrick for informed consent are to witness the signing of the consent, notify a physician if there is no consent on the patient chart prior to a procedure, notify the physician of withdrawal of consent in a timely manner, and also to inform the physician if clarification or additional education needs to be obtained. There are exceptions to obtaining informed consent, but the 2 most common are an emergency where a delay in treatment could cause bodily harm or injury. The second would be if the patient becomes unconscious or incapacitated and there is no next of kin or power of attorney available to make decisions. There are many other exceptions, but for time's sake, we will move along to the basics of advanced directives. All patients have the right to make decisions about their health care, and advanced directives do just that. Advanced directive is an umbrella term used to describe instructions left by a patient that they wish to have utilized when they can no longer make decisions for themselves. There are 3 types of advanced directives: a durable power of attorney, a living will, or a do not resuscitate / allow natural death order. Advanced directives speak specifically to one's end-of-life decisions. A durable power of attorney, or POA, is obtained when a competent adult appoints a proxy in the case that a patient becomes incapacitated. Ideally, the patient would pick someone in which they have a trusting relationship with, and the proxy would carry out the patient's intended wishes. A living will speaks to the extent of which one feels appropriate having life-sustaining support carried out if they are deemed terminally ill or permanently unconscious. A DNR, which is a do not resuscitate or allow natural death, an A&D order, does not mean that a patient will not receive treatment, but does mean that if life-sustaining measures must be taken, they will not be carried out and the patient will be allowed to expire naturally. Physician and healthcare personnel must be aware and have a documented DNR or A&D in the chart before it can be honored. As a nurse, it is important to make sure that a patient and their family members know that their loved one will continue to receive comfort and pain-relieving measures. Some important facts to remember about advance directives is that all of the previously discussed forms of advance directives must be documented, witnessed, and notarized for them to be legal. Also, if no advance directives are in place and a patient becomes incapacitated, the next of kin will be utilized to make the decisions. The order of which that would take place is a spouse. If there is no spouse, they would move on to the adult children making the decisions. If there are no adult children, they would seek out the patient's parents. If the parents could not be contacted, they would seek out the patient's adult siblings. If that fell through, they would move on to the adult nieces, nephews, aunts, or uncles. Then they would move along to any relative that is familiar with the patient. And lastly, if there is absolutely no family left to make decisions, they will let anyone who expresses concern about the patient make decisions regarding end-of-life treatment. Also remember that advance directives may be changed, revoked, or utilized at any time. And as a nurse, according to the ANA, it is our duty to educate, document, and communicate any change within advance directives. Make sure a copy of advance directives are on the patient's chart. Question patients upon admission to the hospital about their wishes, and if they have no advance directives, offer assistance in providing some. Nurses should always provide comfort, pain relief, and advocate for dignified and humane care. That concludes this in-service on basics of confidentiality, informed consent, and advance directives. Thank you.